The law isn't just a dusty collection of rules and old books you find tucked away somewhere. It's more like a living history, isn't it? Forged in the heat of intense conflicts, shaped by surprising decisions, and constantly refined by that very human search for justice.
Welcome to this deep dive. Today we're pulling back the curtain on some of the landmark Australian legal cases. These haven't just defined the nation's laws, but have really profoundly shaped its society, its whole understanding of rights, and the very nature of power within it. So this deep dive is based on a detailed document you've shared outlining 100 defining decisions in Australian history. It covers everything: dramatic criminal trials, complex civil disputes, foundational constitutional battles. We've picked out a key few from that list to unpack for you. Our mission: to dig into these historical legal battles, really extract the most important nuggets of knowledge and insight. We want to help you grasp the core issues at stake, understand the sometimes, unexpected outcomes, and most importantly, show you their lasting ripple effect on Australian law and, maybe surprisingly, on your life today.
Yeah, absolutely. These cases offer a really remarkable journey through time. I mean, spanning from the earliest days of the colony, grappling with that fundamental question of indigenous sovereignty, right through to modern fights over human rights, the balance of federal power, and, the integrity of the justice system itself. It's a real deep dive into the legal roots of contemporary Australia.
Okay, let's jump straight in then, right at the beginning of a colonial history. Where does the law start wrestling with these huge foundational questions?
Well, we have to go back to 1836.
Mm-hmm.
The Supreme Court of New South Wales. This is the case R v Murrell. And right away, you see the colonial legal system confronting Indigenous presence and Indigenous law. An Aboriginal man, Jack Congo Murrell, he was on trial for murder involving another Aboriginal person.
Right, and his defense basically asked, hang on a sec, does British law even apply here? Do these colonial courts actually have jurisdiction over Aboriginal people and their disputes, especially, crimes between themselves? A huge question.
That's exactly it. I mean, this case became the first major legal test of that doctrine. Terra nullius. The idea that Australia was legally empty, no one's land, before the British arrived, and that Indigenous peoples, they just had no recognizable legal system or sovereignty in the eyes of the colonists.
So the fundamental legal puzzle for the court was, okay, whose law governs this land? Was Indigenous sovereignty just invisible to British law?
Precisely. And Justice Burton delivered the decision. The court ruled pretty unequivocally that all people in the colony, Aboriginal inhabitants included, were subject to British law. His reasoning was, it was stark. The colonial court simply did not recognize the existence of any Aboriginal legal system. Full stop.
So just like that, by judicial decree, terra nullius was essentially cemented into Australian law. What's the key insight we should take from that?
I think the chilling insight from Murrell is just how quickly and absolutely the colonial legal system dismissed millennia of Indigenous law in connection to country. It wasn't really that they couldn't see a legal system. It feels more like they chose not to recognize it. And they used that lack of recognition to assert universal British authority. This case established the legal fiction that, underpinned dispossession for over 150 years. You can almost feel the weight of that courtroom. Murrell, maybe through an interpreter, describing a whole world of law and custom completely alien to the judges, and then their swift, absolute dismissal.
Yeah, a foundational injustice just embedded right there in the law. And then just a couple of years later, 1838, the courts faced an even more horrific challenge, didn't they? With R.V. Kilmeister, #2, the Mile Creek Massacre trials.
Yes, Mile Creek. The massacre of at least 28 Aboriginal men, women, and children by settlers. What was shocking, even on the incredibly violent frontier, was that the perpetrators were actually brought to trial at all. The first trial, they were acquitted. Lots of public bias.
But the young Attorney General, John Hebert Plunkett, he didn't let it go, did he? He pushed for a second trial.
He did. He was quite dogged about it. And the central legal question here was incredibly challenging for the time. Could white settlers actually be tried and punished under colonial law for murdering Aboriginal people? I mean, did the rule of law extend to protect Indigenous lives from that frontier violence? Or were those lives just considered outside the law's protection?
And what happened in that second trial? Did they manage to get a different outcome?
They did. They strategically focused on the murder of just one child, which sounds brutal, but it was a tactic to try and secure a conviction. Justice Willis presided. And this time, kind of against the prevailing frontier mentality, the jury found 7 of the perpetrators guilty.
7 men convicted and then executed for the murder of Aboriginal people. That must have sent absolute shockwaves through the colony.
Oh, it was a landmark moment. The first time British subjects were actually executed for a massacre of Indigenous people in Australia. The insight here, I think, is that while the system was deeply, deeply flawed and biased, there were individuals like Plunkett pushing for some kind of accountability. And there were these moments where justice, however fleeting, could actually break through the frontier violence. The tension in that courtroom must have been immense. Indigenous witnesses bravely giving evidence, the public backlash against the very idea of holding settlers accountable. It was a deeply conflicted moment. That guilty verdict was such a rare assertion that Indigenous lives did, in theory, fall under the protection of colonial law, even if that principle was, rarely applied consistently for decades afterwards.
So we see the early courts grappling with who is subject to the law, whose life is valued by it. Moving forward a bit, law also confronts rebellion and the people's will. Fast forward to 1855 and the trials of the Eureka rebellion leaders.
Ah, the Eureka stockade. Yeah. Gold miners resisting colonial authority over these really oppressive license fees, culminating in that armed clash. 13 rebel miners were charged with the highest crime imaginable. High treason.
Treason? Wow. So the legal question was, okay, did this armed resistance against what they saw as oppressive laws actually constitute a fundamental betrayal of the crown? And how would the formal legal system respond when faced with a popular uprising demanding reform?
Well, the trials were held in Melbourne, and they became this huge public spectacle. Public sympathy had really swung strongly towards the diggers. People felt they were fighting for basic fairness against corrupt officials and unfair laws.
And then, in a pretty remarkable turn, the juries acquitted all 13 accused rebels. Every single one.
Unanimously acquitted. Despite, pretty clear evidence of their involvement in the stockade fight. The fascinating insight here is the sheer power of jury nullification. Even when the law on the books clearly said this was treason, the community, represented by that jury, effectively refused to apply it. They just wouldn't brand the miners as traitors, siding instead with their grievances against unjust laws.
That's such a powerful expression of community values overriding the strict letter of the law, isn't it?
Absolutely. It's often seen as a pivotal moment for Australian democracy. None of the rebels were convicted, and crucially, their demands like abolishing the license fees, getting voting rights, were largely met pretty soon after. It underscored this emerging value system centered on the fair go, and the legitimacy of protesting unjust authority. You can just imagine the packed courtroom, the passionate speeches from the defense, the roar of approval each time a not guilty verdict came back. It was a real moral victory that forced legislative change.
From democratic rebellion to maybe the ultimate outlaw figure. Our next case is instantly iconic. R.V. Edward Kelly, Ned Kelly, in 1880.
The infamous bushranger, yeah. Captured after that dramatic siege at Glenrowan. Brought to Melbourne to stand trial for murder.
And while it was a murder trial at its heart, Ned Kelly's case really embodied these larger societal tensions, didn't it? The struggle of the rural poor, that Irish-Australian resentment towards British authority, the perceived unfairness of the colonial police force.
Exactly. The trial was presided over by Justice Redmond Barry. Kelly, even though he was shackled, was incredibly defiant. He famously sparred with Barry from the dock and delivered this really bold speech asserting his side of the story, proclaiming, no one understands my case as I do.
But the evidence against him, despite his charisma, it was pretty clear, wasn't it?
It was. The jury took only minutes, really, to find him guilty of the murder of Constable Lonigan. Justice Barry sentenced him to death. Kelly was executed at Old Melbourne Jail shortly after, uttering those famous last words, "Such is life."
What's the key insight we should take from the Ned Kelly trial, beyond the legend?
Well, legally, it marked the definitive end of the bushranger era as a form of, popular rebellion. It affirmed the rule of law over that kind of frontier vigilantism. But the lasting insight is overwhelmingly cultural, isn't it? Kelly's trial, particularly his voice from the dock highlighting perceived injustices, that solidified his legend. He became this powerful, enduring symbol of resistance against perceived authority and inequality, deeply embedded in the Australian identity. That defiance, even in the face of formal law, is what makes his story and his armor still resonate so strongly today. And there's that sort of poignant, almost haunting detail. Justice Barry himself died just days after sending Kelly to the gallows.
From grappling with basic authority to the complexities of a new federation, let's move into the 20th century and look at how the law began to define economic rights and federal power. First up, Ex parte H.V. McKay from 1907, famously known as the Harvester case.
Right. This wasn't a dramatic criminal trial, but a civil arbitration case. It was all about a fair and reasonable wage at H.V. McKay's huge agricultural implement factory. He needed to prove he paid one to get an exemption from a federal excise tax.
Fair and reasonable, that simple phrase became the central legal puzzle, didn't it? What did that actually mean in practice? How could a court possibly determine a fair wage?
Well, Justice Henry Bourne Higgins, who was presiding over the new Commonwealth Conciliation and Arbitration Court, took an incredibly pioneering approach for his time. He looked beyond just dry legal or economic arguments. He decided to find out what it actually cost an unskilled laborer to live decently and support a family. And he did something really quite unprecedented. He called workers and, crucially, their wives to testify.
So they were literally coming into court and talking about their household budgets, their rent, their grocery bills, things like that.
Exactly that. He heard direct evidence about the reality of working-class life. And based on all that testimony, he determined that a fair minimum wage was 7 shillings a day, or 42 shillings a week. This, he said, was the minimum necessary for a human being to live decently in a civilized community. McKay was paying less, so he didn't get the tax exemption.
That sounds like a huge win, establishing a living wage based on need.
Socially, it had a profound impact, yes. Although, and this is a bit of a twist, the High Court later struck down the specific tax law that triggered the case on constitutional grounds. So technically, Higgins's ruling became void in a strict legal sense.
Oh, okay, that is a twist.
It is. But the ideal and the standard Higgins set, well, that's stuck. His basic wage became the benchmark in Australia for close to 70 years. The lasting insight here is how Justice Higgins used the law and this technical tax exemption case to build a powerful social standard, the concept of a living wage based on human needs, not just market forces. It really cemented the arbitration court's role in social justice and marked the birth of Australia's enduring minimum wage tradition. It was a moment where a judge deliberately looked beyond the legal text to the lived human reality to define what fairness actually meant.
A powerful idea, even if the specific legal mechanism was later overturned. Following on from that, another really pivotal constitutional moment that redefined federal power. Amalgamated Society of Engineers v. Adelaide Steamship Co. Ltd. in 1920, the engineers case.
Right, this started innocuously enough, just an industrial dispute asking if Commonwealth labor law could bind state government agencies, like state railways. But it rapidly morphed into a fundamental re-examination of 20 years of constitutional doctrine that had deliberately limited federal power to protect the states.
Yeah, because for the first 2 decades after Federation, the High Court had interpreted the Constitution using these doctrines like implied intergovernmental immunities and reserved state powers, didn't they? Essentially carving out areas where federal laws just couldn't tread to protect state autonomy.
The engineers case basically just threw all of that out the window. The High Court, in a sweeping 5-1 decision led by Justice Isaac Isaacs, explicitly rejected those old doctrines. They declared a new era. Commonwealth powers should be interpreted broadly, based purely on the text of the Constitution itself, without any built-in assumption that state authority needed protecting. If the power is granted to the Commonwealth in the text, it's full power.
So no more assuming there are these inherent state areas automatically off limits to the Commonwealth just because of history or tradition.
Precisely. Isaacs famously said the Constitution should be read with literal fullness. Federal laws, like industrial laws, could apply to state agencies if the federal power covered the subject matter. End of story.
Here's where it gets really interesting. This decision sounds like a fundamental rewriting of the rule book for federalism in Australia.
It absolutely was. It's genuinely one of the most important decisions in Australian constitutional history. The key insight is how a shift in how judges interpreted the Constitution, moving away from assumptions about maintaining a certain federal-state balance to a strict, literal reading of the text, fundamentally rewrote the balance of power. It really marked the end of that initial states' rights dominance and began the era of expanding Commonwealth power. It paved the way for a much more centralized federal structure and the textualist approach that defined High Court interpretation for decades after. You can just imagine the shockwaves among lawyers who'd built their entire careers on understanding those old doctrines. The High Court effectively declared their foundational understanding obsolete overnight.
A truly dramatic shift in how the nation's power dynamics were understood through law. Okay, so we've seen courts tackle sovereignty, rebellion, and the balance of state and federal power. Now, let's look again at how the justice system confronted its own biases, particularly towards Indigenous Australians, building on those early struggles we saw with Murrell and Myall Creek.
Yes, in 1934, we have the very stark case of Tuckyar v. the King. This involved Tuckyar, an Aboriginal Yolngu man convicted of murdering a white police constable up in the Northern Territory.
And his trial in Darwin is described as being absolutely rife with injustices.
Massively so. Takiar spoke no English. He was facing a legal system completely foreign to him. But perhaps the most shocking element was the conduct of his own defense counsel, who basically conceded Takiar's guilt in court and pleaded for mercy, acting directly against his client's interests and instructions.
That's a fundamental violation of a lawyer's duty, isn't it? What was the key legal question the High Court had to confront when it went up on appeal?
Well, it was whether that conviction could possibly be safe, given the profound procedural unfairness, the lawyer's absolutely improper conduct, and the systemic biases clearly operating in the system. Could an appellate court step in when the trial process itself was just so fundamentally compromised? The High Court, on appeal, was scathing in its judgment. Unanimously, they quashed Takiar's conviction and sentence. They strongly condemned the defense lawyer's conduct, calling it a betrayal of his client. They also raised serious questions about using Takiar's alleged admissions to police when he clearly didn't understand the process or what he was saying.
So they clearly recognized the deep miscarriage of justice that had occurred there.
Absolutely. They ordered his release immediately. The lasting insight from Takiar is its status as a really foundational case on proper legal ethics, that a lawyer must never act against their client's interests no matter what. It also powerfully highlighted the immense cultural and language barriers indigenous people faced in colonial courts. Tragically, Takiar's fate after release remains unknown. He disappeared, likely fearing further repercussions. But the case stands as an important early High Court recognition that the rights of an accused person, regardless of their race or background, must be rigorously protected to ensure even a semblance of a fair trial.
A critical early step in acknowledging those systemic issues, though justice was clearly imperfect and tragically incomplete for Takiar himself. Following that, another major constitutional battle, this one from 1942, right in the middle of the urgency of World War II. South Australia v. Commonwealth, the first uniform tax case.
Right. With the nation at war, the Commonwealth government, under Prime Minister Curtin, needed to consolidate financial power, urgently. They moved to take over income tax collection exclusively, effectively preventing the states from levying their own income tax. The states, led by South Australia, saw this as a massive, unconstitutional power grab and challenged it fiercely in the High Court.
A really high-stakes constitutional showdown over who controlled the nation's primary source of revenue right when the nation needed it most. What was the core legal question?
Could the Commonwealth constitutionally implement this uniform income tax scheme? Could they use their taxation power and also their power to make conditional grants to states under Section 96 in a way that effectively crowded out the states from the income tax field? Was this scheme illegal coercion of the states, undermining the federal balance? The High Court, in a 4-2 decision on the key points, upheld the Commonwealth's uniform tax scheme. They ruled that the federal income tax was valid even if it left no practical room for states to levy their own. The Commonwealth's motive didn't make the law invalid. And they found the grants offered to states, essentially compensating them if they agreed not to collect income tax, were valid under Section 96. They saw it as a legitimate financial inducement, not illegal coercion. The wartime context, under the defense power, also played a significant role in the judgment.
So this decision solidified a massive power shift towards the Commonwealth, didn't it? Leveraging their financial might.
It was an absolute watershed moment in Australian federalism. The key insight here is how the Commonwealth, using its constitutional powers, interpreted broadly, remember, after the engineers case, could achieve significant centralization through financial means, legally squeezing the state's fiscal autonomy. It permanently entrenched what we call vertical fiscal imbalance, where the Commonwealth collects the lion's share of revenue and distributes funds back to the states, often with conditions. The states never got income tax back after the war. This enabled the federal government's dominant role in post-war nation-building and major social programs, all funded from Canberra. You can imagine the state premiers arguing desperately in court about financial strangulation, and the High Court, perhaps influenced by the wartime urgency, prioritizing national necessity and delivering a judgment that fundamentally reshaped the financial architecture of the Federation forever.
Financial power consolidating right there at the center. And that theme continues after the war with Bank of New South Wales v. Commonwealth in 1948, the bank nationalization case.
Yes. The post-war Labour government under Ben Chifley aimed to nationalize all the private banks, transferring their business to the government-owned Commonwealth Bank. They genuinely believed this was vital for controlling credit and planning the post-war economy effectively. But this plan provoked massive opposition from the banks themselves, several states, and much of the public, leading to a huge legal and political battle. So what was the core legal question the High Court had to grapple with this time?
Was the Bank Nationalization Act actually constitutional? Could the government just pass a law taking over entire private businesses like this? It hinged on several constitutional powers, but crucially, Section 5131, the bit that guarantees just terms for any acquisition of property by the Commonwealth. Did the law provide fair compensation, or did it amount to confiscation? The case also raised serious questions about access to the courts and the separation of judicial power because the act tried to limit the bank's ability to challenge it legally. The High Court, and later the Privy Council in London on final appeal, struck the law down. It was a significant defeat for the Chifley government. They found it violated Section 5131 because it acquired shareholder property, essentially their shares and interest in the banks, without providing what the court considered to be just terms. They were also deeply critical of provisions that tried to bar the banks from accessing the courts, seeing that as an attempt to undermine judicial power and the fundamental rule of law.
So the court effectively drew a line in the sand, didn't it? Even against a democratically elected government with a clear policy goal. What's the lasting insight from this one?
I think the key insight is how this case served as a defining check on legislative power in Australia. It powerfully demonstrated that constitutional guarantees like the right to just terms for property acquired by the Commonwealth and the right to access the courts couldn't just be steamrolled, even for a government's major policy agenda. It was a significant victory for private property rights and helped cement a really robust interpretation of just terms. It's often seen as one of the judiciary's key moments where it strongly asserted the rule of law's limits on government action, preventing Parliament from simply legislating away fundamental rights and access to legal challenge. Imagine the drama bankers rushing to court for injunctions, the high-powered legal arguments about foundational constitutional principles.
A powerful affirmation of property rights and judicial checks on government power. And that theme, the rule of law versus government power, is echoed, perhaps even more dramatically, isn't it, in the Australian Communist Party v. Commonwealth case in 1951, the Communist Party case.
Oh, absolutely. This unfolded right at the height of Cold War fear and anti-communist sentiment. The Menzies government passed the Communist Party Dissolution Act 1950. This law didn't just criminalize certain actions, it simply declared the Communist Party of Australia illegal, ordered its dissolution, allowed for the seizure of its property, and even let the government declare individuals as communists, barring them from certain jobs or holding office in unions. And all this was done by legislative declaration, completely bypassing the need for any proof or trial in a court of law.
So the government was basically using Parliament to act as judge, jury, and executioner, declaring guilt and imposing punishment without involving the judiciary at all?
Exactly that. And the fundamental legal question was, could Parliament actually do that? Could it just declare an organization and its members guilty and effectively dissolve them by statute without any judicial process? Was this somehow justified under the defense power even in peacetime? Or was it an unconstitutional exercise of judicial power by the legislature, effectively what's called a bill of attainder? The High Court, in a landmark 6-1 majority decision, struck the act down completely. They ruled it wasn't justified by the defense power in peacetime. But crucially, they found the act violated the separation of powers doctrine embedded in the Constitution by seeking to bypass the judiciary altogether. Parliament simply couldn't declare subversion without proof being established in a court of law.
And this is where Justice Dixon's really powerful words resonate, isn't it?
They do. His famous line captures the absolute essence. History shows, in periods of stress or disturbance, that necessity is the plea for every infringement of human freedom. It is the argument of tyrants. The court insisted quite firmly that a person or organization's legal status couldn't be destroyed merely by Parliament's declaration. Facts had to be proven according to law in court.
This is widely seen as one of Australia's greatest rule of law victories, isn't it? A really foundational case.
Absolutely. The key insight is how forcefully the High Court defended the principle that Parliament is limited by the Constitution and cannot just dispense with the courts, even in a climate of significant political fear and intense pressure. It insisted that allegations of subversion or disloyalty must be proven under the law, not just asserted by the government of the day. It completely thwarted Menzies' anti-communist legislative crusade. He later lost a referendum trying to achieve the same goal, and solidified the Constitution as a charter of limited government. It stands as a tall pillar of civil liberty, protecting even unpopular minorities from arbitrary laws. The political heat at the time, the atmosphere of fear, juxtaposed with the court's principled stand on legal process, it's a really powerful story of judicial independence prevailing over political expediency.
And speaking of the separation of powers, our next case, R.V. Kirby, Ex parte Boilermakers Society from 1956, also dealt with this fundamental principle, didn't it? But in a very different context. The Boilermakers case.
That's right. This legal saga had a rather mundane beginning, actually. A union, the Boilermakers Society, was fined for contempt by the Commonwealth Court of Conciliation and Arbitration. The union, in challenging the fine, decided not just to argue the merits, but to attack the very structure of the court that imposed it.
So the central legal puzzle was the structure of that arbitration court actually constitutional? Because it was a kind of hybrid body, wasn't it? Exercising both judicial power, like enforcing penalties and punishing contempt, and non-judicial administrative or arbitral power, like setting wages and working conditions.
Exactly. The question was, does Chapter 3 of the Constitution, which vests federal judicial power only in designated courts with specific safeguards like independence and tenure, allow a body with significant non-judicial functions to also exercise federal judicial power? Could you actually mix those roles, judge and arbitrator, in the same federal institution?
And the High Court's answer was?
A very firm no. In two key decisions, they ruled that the arbitration court's structure violated the separation of federal judicial power required by Chapter 3. The Boilermakers Principle, as it became known, established that federal judicial power can only be exercised by strict Chapter 3 courts, and those courts generally cannot be given functions that are incompatible with their judicial role. Mixing the administrative task of setting wages with the judicial task of enforcing orders and punishing contempt was deemed unconstitutional.
The union that essentially broke the court's structure. What's the core insight here? Why does this seemingly technical case matter so much?
The key insight from Boilermakers is how it constitutionalized and rigorously reinforced Australia's separation of federal judicial power. It's seen as a bedrock principle. Federal judicial power must be kept separate and pure from other forms of government power. It led directly to a major restructuring of the entire federal industrial relations system, splitting the arbitral wage setting and judicial enforcement functions into two distinct bodies, the Conciliation and Arbitration Commission and the Commonwealth Industrial Court. It stands for the crucial proposition that you cannot blend judicial power, which involves adjudicating guilt, imposing penalties, with non-judicial functions like policymaking or administration in a single federal tribunal. It's a powerful illustration of how abstract constitutional principles about the structure of government, triggered by a seemingly small dispute, can have significant, lasting practical consequences for how government actually functions and how power is organized.
Abstract principles with very real-world impacts. Okay, moving back now to how the justice system handles individuals, particularly those most vulnerable to its biases. We touched on Tucker. Let's look at Stuart v. the Queen in 1959. Max Stuart.
Yes, this was a deeply troubling case that went all the way to the Privy Council in London, which was Australia's final court of appeal at the time. Max Stuart, an Aboriginal Arunte man, was convicted in South Australia of the rape and murder of a young girl. But his trial was just riddled with serious issues. He had very limited English. His confession, the main piece of evidence, was allegedly coerced after intensive police interrogation, and critically, there was no interpreter provided for him during the actual trial.
No interpreter.
Yeah.
Facing capital charges in a language and legal system he barely understood, that immediately screams potential miscarriage of justice, doesn't it?
It absolutely does. Despite these major doubts and a death sentence being imposed, his initial appeals through the Australian courts failed. The core legal question that emerged through the appeals and public outcry was whether his conviction could possibly be considered safe, given the profound doubts about the confession's validity and the fundamental lack of proper support and understanding provided to him throughout the legal process. It also raised broader questions about whether executive action, like clemency or even a royal commission, could or should step in when formal legal avenues seemed insufficient to address such apparent injustices. Well, while the High Court didn't find sufficient legal error on appeal at that time to overturn the jury's verdict, they felt bound by the trial record. Public pressure mounted significantly, fueled largely by investigative journalism, particularly from Rupert Murdoch's newspaper, The News, in Adelaide. Facing execution, Stuart was granted last-minute clemency due to this intense public and political pressure. A subsequent royal commission controversially upheld the conviction itself, but his death sentence was formally commuted to life imprisonment, and he was eventually released on parole after serving 14 years.
So, what's the enduring insight from Max Stuart's case? It didn't result in immediate legal exoneration, did it?
No, not in the traditional sense, though the commutation was huge. The key insight, I think, is its powerful, stark exposure of the systemic disadvantages faced by indigenous defendants in the legal system at that time, particularly the devastating impact of language barriers, lack of cultural understanding, and deeply problematic police interrogation practices. It did spur some reforms in how indigenous suspects were handled and highlighted the critical need for interpreters. While the formal legal process didn't fully vindicate him initially, that came much later with the commutation and his release, the case became a national story, almost a saga. It underscored how justice can tragically miscarry, even in the most serious cases, due to cultural gaps and a lack of procedural fairness. It left a lasting legacy in discussions about indigenous justice and was later immortalized in books and the film Black and White.
A really chilling reminder of systemic flaws and the power of public pressure. From a life hanging in the balance due to potential injustice, to the case that marked the definitive end of capital punishment in Australia. R.V. Ryan in 1967. Ronald Ryan.
Yes, Ronald Ryan. He was an escaped prisoner convicted of murdering a prison warder during a breakout from Pentridge Prison in Melbourne in 1965. It was a highly public trial, but it came at a time when public sentiment across Australia was increasingly turning against the death penalty. It hadn't been used for some years.
The core legal issue in the trial itself involved some debatable evidence about whether Ryan actually fired the fatal shot. There was another escapee involved. But after his appeals failed, the ultimate legal and political question really became one of executive discretion, didn't it? Would the Victorian government, led by the famously hardline Premier Henry Bolt, exercise the royal prerogative of mercy and commute the death sentence, which had essentially become the customary practice in Australia by the 1960s?
Premier Bolt refused, determinedly refused. Against enormous public opposition, there were petitions, large protests, appeals from church leaders, academics, lawyers, unions. He was absolutely determined to proceed with the execution. He portrayed it as a necessary stand for law and order, being tough on crime. Despite frantic last-minute legal attempts, including a dramatic midnight high court hearing seeking a stay, Ryan was hanged at Pentridge Prison on 3 February 1967.
And that became the very last execution carried out in Australia.
It did. The execution sent absolute shockwaves across the nation. The widespread public revulsion and distress, the feeling that something anachronistic and wrong had occurred, effectively cemented the end of capital punishment in Australia. The remaining states that technically still had it on the books quickly moved to abolish it formally in the following years. The key insight from Ryan's case is how a single, highly controversial exercise of executive power, seen by many as defying prevailing social sentiment and raising lingering questions about the fallibility of the evidence in his case, actually galvanized public will and brought an end to a practice that had existed since colonization. It's a grim story, absolutely, but one that marks a very clear turning point in Australian social values and the complex relationship between executive power, the law, and the public conscience.
A truly somber moment that closed a very dark chapter in Australian legal history. Now shifting to another sensitive social issue that the courts had to grapple with, R.V. Davidson in 1969, the Menhennet abortion ruling.
Right. This case involved a Dr. Charles Davidson, a young doctor in Melbourne, who was charged with performing illegal abortions. At the time, Victorian law was extremely restrictive, technically only permitting abortion to save the mother's life. It was very vague beyond that.
So the central legal puzzle wasn't just about Dr. Davidson's guilt or innocence, but about interpreting that vague and restrictive law itself. What exactly constituted a lawful therapeutic abortion under Victorian law? When could a doctor legally terminate a pregnancy without facing criminal charges?
Justice Clifford Menhennet, who was presiding over Davidson's trial in the Victorian Supreme Court, delivered a landmark ruling that provided this crucial interpretation. He defined the circumstances under which an abortion would be considered lawful. He ruled that an abortion would be lawful if the doctor held an honest and reasonable belief that the procedure was necessary to preserve the woman from serious danger, not just to her life, but also to her physical or mental health. And critically, this danger had to be beyond just the normal risks associated with pregnancy and childbirth.
Including mental health in that equation was quite a progressive step for 1969, wasn't it?
It was, very much so. His ruling significantly expanded the legal understanding of the health exception under the existing law. Applying this newly articulated test, the charges against Dr. Davidson were actually withdrawn during the trial, as the prosecution conceded they couldn't prove his actions fell outside these criteria.
So this ruling, delivered by a single judge in a criminal trial, effectively created a set of conditions under which abortion could be considered lawful in Victoria, becoming a de facto standard for doctors.
Exactly. Menhenet's criteria became the working standard in Victoria,
and heavily influenced similar judicial rulings in other Australian states in the years following. It began a crucial, albeit slow shift away from treating abortion purely as a criminal matter towards more of a health law approach, decades before widespread legislative reform decriminalized abortion across the country. The key insight here is how a single judge, carefully interpreting an old, vague law in the context of a specific criminal trial, could effectively create a legal safe harbor for doctors, and importantly, acknowledge a broader understanding of a woman's health, including her mental well-being. It highlights the power of judicial interpretation to cautiously adapt the law to evolving social understandings and medical realities, even when politicians were hesitant to act.
We've seen how courts have wrestled with the legacy of the past and interpreted laws to reflect changing social norms. Now, let's turn to some truly monumental cases from the late 20th century that fundamentally reshaped the nation, particularly around land rights, the environment, and the very nature of fundamental freedoms. Starting with Milirpum v. Nabalco in 1971, the Gove land rights case.
Yes, this was Australia's very first major Aboriginal land rights lawsuit. The Yolngu people in Arnhem Land, up in the Northern Territory, took on a huge mining company, Nabalco, and the Commonwealth government itself. They were seeking recognition of their traditional ownership of lands where the company wanted to mine bauxite, trying to stop the mining on their sacred traditional lands.
And this is the case where terra nullius, that legal fiction we discussed right back with Murrell in 1836, faced its first direct, comprehensive legal challenge in an Australian court.
It was exactly that. The central legal question was incredibly stark. Would Australian common law finally recognize Indigenous customary title or native title, as it came to be known? Could the ancient rights and connections of Aboriginal clans, which clearly predated colonization, be upheld in court against government-granted mining leases? Justice Richard Blackburn, sitting in the NT Supreme Court, delivered the judgment. He listened intently to the Yolngu elders. He acknowledged their deep spiritual connection to the land, their complex traditional laws. He documented it all very respectfully. But feeling bound by the existing legal precedents in the state of the common law at that time, he ultimately ruled that communal native title was not recognized by Australian law. He held that upon colonization, ownership of all land vested absolutely in the Crown, and any pre-existing Indigenous rights were not preserved by the common law. He stated quite famously that while the Yolngu's relationship to the land was profound and spiritual, it didn't amount to legally enforceable property rights in the eyes of the common law. He concluded that any recognition of such rights was a matter for Parliament, not for the courts to create.
So despite the powerful case the Yolngu presented, using things like traditional bark petitions as evidence in court they lost, terra nullius was judicially upheld, yet again.
It was a significant legal defeat, absolutely heartbreaking for the Yolngu people. But the profound insight from Milirpum, I think, is how a judicial defeat could paradoxically lay the crucial groundwork for future victory. Justice Blackburn's detailed and respectful documentation of Yolngu law in connection to country, and his very use of the term native title throughout the judgment, planted a really important seed in the legal and public consciousness. It galvanized public support for Aboriginal land rights and directly contributed to political pressure that led to the passage of the first statutory land rights legislation, the Anti-Aboriginal Land Rights Act, just 5 years later by the Fraser government. It was the last major judicial affirmation of terra nullius. And in losing, the Yolngu people spurred the movement that would eventually see that doctrine definitively overturned 2 decades later in Mabo. It's a powerful story of perseverance, using the legal system itself to document and assert rights, making the invisible visible even in initial defeat.
A truly pivotal defeat that paved the way for future triumph. Okay, next, a different kind of rights case. This one dealing with the often fraught relationship between church and state. Attorney General Vic Rell, Black v. Commonwealth in 1981, better known perhaps as the Dogs case.
Yes, Dogs Yes stood for Defense of Government Schools. This case was brought by that lobby group who challenged the Commonwealth government's policy of providing funding to non-government schools, which in Australia were then and still are largely Catholic or other faith-based schools. They argued that providing this financial aid to religious schools violated Section 116 of the Australian Constitution.
Right, Section 116. That's the one that says the Commonwealth shall not make any law for establishing any religion or for imposing any religious observance. What was the central legal question the High Court had to decide here?
Well, did Commonwealth funding grants to religious schools actually amount to establishing a religion or imposing religious observance, contrary to Section 116? Was Section 116 intended to create a strict separation of church and state? maybe similar to the Establishment Clause of the First Amendment in the United States? Or did it have a much more limited, narrow meaning? The High Court, in a decisive 6-1 majority decision, upheld the government's aid to religious schools. They interpreted Section 116 very narrowly. They ruled that it primarily forbids the Commonwealth from creating an official state church or legally forcing people to participate in religious observances or pass religious tests for office. Critically, they held it does not prevent the government from providing financial assistance to religious institutions for secular purposes, such as education. Funding the running of schools, even religious ones, was seen as legitimate support for education and welfare, not an establishment of religion in the constitutional sense.
So this case essentially confirmed that Australia does not have a strict separation of church and state doctrine like the U.S. The government can fund religious schools?
That's the key insight, yes. The Dodgiest case confirmed that Section 116 provides a very limited guarantee of religious freedom at the federal level, mainly focused on preventing a national church. It cleared up any constitutional doubt about the validity of federal funding for faith-based schools, a policy which has subsequently become deeply entrenched and expanded. The ruling showed that Section 116 is not easily breached and doesn't prevent significant government cooperation with and funding of religious bodies, especially in areas like education, health, and welfare. The sole dissenter, the always interesting Justice Lionel Murphy, argued for a much broader American-style separation, warning of the dangers of entanglement, but the narrow majority view prevailed decisively, meaning Section 116 has remained, for the most part, a relatively weak constitutional provision compared to its U.S. counterpart.
From debates about religious funding to fundamental human rights and the growing power of international treaties in Australian law, in 1982, Kawarta v. Bjelke-Petersen.
Yes, this is a deeply personal story that triggered a major constitutional shift. John Kawarta was an Aboriginal Wickman from Cape York in Queensland. He and his community sought to buy a pastoral lease, a cattle station, using funds provided by a Commonwealth body, the Aboriginal Land Fund Commission. But the Queensland government, under the notoriously conservative Premier Job Bjelke-Petersen, openly and explicitly blocked the sale solely because the buyers were Aboriginal. They had a stated policy against large Aboriginal landholdings.
Blatant, overt racial discrimination by a state government.
Precisely. Kawarta sued the Queensland government, arguing their action violated the Federal Racial Discrimination Act 1975, the RDA. Now, the RDA was a law passed by the Commonwealth Parliament specifically to implement Australia's obligations under an important international treaty, the Convention on the Elimination of All Forms of Racial Discrimination, CERD. Queensland, in turn, didn't just defend its policy, it challenged the constitutional validity of the RDA itself.
Okay, so the central legal question became massive. Could the Commonwealth actually use its external affairs power, Section 51 of the Constitution, the power to make laws with respect to external affairs, including treaties to legislate on something like racial discrimination, which might otherwise be seen as a state matter like land policy, simply because Australia had signed an international treaty on the topic? And if the RDA was valid, was Queensland's discriminatory land policy invalid because it conflicted with the federal law under Section 109 of the Constitution?
The High Court, in a very close and controversial 4-3 majority decision, upheld the validity of the RDA as a legitimate exercise of the external affairs power. They ruled that implementing a bona fide international treaty, like the one against racial discrimination, did allow the Commonwealth to pass laws on that subject, even if it significantly intruded upon areas traditionally seen as within state domain, like land management. And crucially, because the RDA was valid, Queensland's discriminatory refusal to approve the lease transfer was found to be unlawful under the RDA and therefore invalid due to inconsistency with the federal law.
Wow. This sounds like a monumental expansion of federal power via the signing of international treaties.
It absolutely was. That's the key insight from Kawarta. It dramatically confirmed and expanded the Commonwealth's ability to legislate on almost any subject by signing and implementing international treaties. It opened up a vast new avenue for federal legislative power, paving the way for later landmark federal laws on environmental protection, as we'll see, and other human rights matters, often overriding state laws. It also cemented the constitutional status and importance of the RDA, a law which would become a crucial shield for Indigenous rights in the upcoming Mabo litigation. It was a significant defeat for the kind of institutionalized racism practiced by the Queensland government at the time, triggered by one man's fight for fairness, leading to a lasting shift in the constitutional landscape. You can picture John Kawarda and his community's dream of buying back that land, contrasted with the cold political calculation in Queensland, and then the powerful legal arguments in the High Court connecting Australia's domestic laws to its international human rights obligations.
And the power of that external affairs power was dramatically demonstrated again the very next year, wasn't it, in 1983, with Commonwealth v. Tasmania, the legendary Tasmanian Dams case.
Yes, the Franklin River. This case became a national, even international, sensation. The Tasmanian government planned to build a large hydroelectric dam on the Franklin River, a truly wild and pristine river in Tasmania's southwest wilderness, an area that had been nominated for World Heritage listing under the UNESCO Convention. Environmentalists across Australia protested fiercely. It became a huge national campaign. The newly elected federal Labor government under Bob Hawke pledged to stop the dam, declared the area World Heritage, and passed a specific federal law, the World Heritage Properties Conservation Act, to prevent the dam's construction. Tasmania, furious, challenged the Commonwealth's power to do this in the High Court.
Okay, so the central legal question was very similar to Kawarta, but perhaps even more pointed. Could the Commonwealth constitutionally use its external affairs power, and potentially other powers like the corporation's power, to enact environmental legislation that clearly intruded into traditional state responsibilities like land use planning and resource development? Specifically, was the Federal World Heritage Act a valid exercise of the external affairs power because it was implementing Australia's obligations under the UNESCO World Heritage Convention?
The High Court, in another incredibly close and highly anticipated 4-3 decision, upheld the Commonwealth law and stopped the dam. The majority ruled that the external affairs power did enable the Commonwealth to legislate to fulfill its obligations under a bona fide international treaty, like the World Heritage Convention requiring protection of listed sites, even if that meant overriding a state's development plans for its own territory. They also found some support for the law and the corporation's power regarding its application to Tasmania's Hydroelectric Commission, a state-owned corporation.
So, effectively, signing an international environmental treaty gave Canberra the constitutional power to veto a state's major infrastructure project based on environmental grounds.
That's essentially the key insight, yes. The Tasmanian Dams case is one of the most significant and debated constitutional cases in Australian history. It massively confirmed and arguably expanded the scope of federal power achievable via the external affairs power, building directly on Kawarda. It confirmed that implementing bona fide international treaties allows the Commonwealth to legislate on almost any subject covered by the treaty, dramatically altering the balance of power with the states, particularly in areas like environmental protection and human rights. It ushered in a new era of Commonwealth leadership in environmental conservation. The Franklin River was saved, becoming a potent symbol for the environmental movement in Australia and globally. The case was, and remains, controversial, especially in Tasmania, where it was seen by many as unwarranted federal overreach into state affairs. But it set a powerful precedent for nationwide environmental and heritage protection funded and legislated by the Commonwealth. You can easily picture the dramatic scenes, the protesters in kayaks facing down bulldozers, the blockades, Bob Brown being arrested, the high-stakes courtroom arguments pitting states' rights and economic development against international obligations and national environmental values, and then the moment the judgment was delivered. The Commonwealth law is valid, triggering jubilation among environmentalists and deep frustration in Tasmania.
Incredible how international agreements can fundamentally reshape domestic power dynamics and even save rivers. Now, shifting back to justice for individuals, a case that absolutely captivated and divided the nation, highlighting potential flaws in the justice system in a really harrowing way. Chamberlain v. the Queen in 1984, the Lindy Chamberlain case.
Yes, the dingo baby case. It stemmed from the disappearance of 9-week-old baby Azaria Chamberlain from a tent near Uluru, then known as Ayers Rock, back in 1980. Her mother, Lindy Chamberlain, consistently maintained from the very beginning that a dingo had entered the tent and taken her baby. It became one of Australia's most sensational, media-saturated, and deeply divisive trials, fueled by intense, often inaccurate media scrutiny, wild public speculation, and considerable prejudice against the Chamberlains, partly due to their Seventh-day Adventist faith, which was unfamiliar and suspect to many Australians at the time.
And despite the lack of a body and Lindy Chamberlain's consistent story, she was convicted of murder, wasn't she? And her husband, Michael, convicted as an accessory after the fact.
She was. The prosecution case relied heavily on circumstantial evidence and, crucially, on highly controversial forensic evidence, particularly alleged blood stains found in the family car, which was later shown to be completely wrong. It wasn't blood at all in many instances. The central legal issues that arose through the appeals process were the reliability of that forensic evidence, the sheer impossibility of getting a fair trial amid such intense media frenzy and public prejudice, and crucially, whether later discovered new evidence could cast sufficient reasonable doubt on the conviction to warrant it being overturned.
And new evidence did emerge years later, didn't it? The matinee jacket.
Yes, that was pivotal. In 1986, Azaria's matinee jacket, the little jacket she was wearing, was found partially buried near a dingo lair in the area, showing damage consistent with a dingo attack. This discovery completely undercut the prosecution's theory and strongly supported Lindy's account. After years of appeals and campaigning, this led to a royal commission which meticulously reviewed the case. Following the commission's findings, the Northern Territory Court of Criminal Appeal in 1988 unanimously quashed the convictions against both Lindy and Michael Chamberlain. They found grave errors and unreliability in the forensic evidence presented at the original trial and accepted that the new evidence strongly supported the dingo hypothesis. Lindy was pardoned and released after serving over 3 years in prison.
And then ultimately fully vindicated by a coroner decades later in 2012 who officially recorded a dingo attack as the cause of Azaria's death. What's the enduring insight from the incredibly sad and complex Chamberlain case?
I think the key insight from Chamberlain is its powerful, devastating illustration of how miscarriages of justice can occur, even in high-profile cases in a modern legal system. It shows what can happen when flawed or misrepresented forensic science is combined with intense public prejudice, media sensationalism creating a hostile atmosphere, and perhaps confirmation bias within the investigation and prosecution. It exposed significant flaws in forensic techniques used at the time and certainly led to improved standards and much greater caution in presenting such evidence in court. It stands as a stark cautionary tale about how easily public emotion, rumor, and preconceived notions can infiltrate the legal process and potentially override the fundamental presumption of innocence. The long journey from public condemnation, the "Dingo's got my baby" line, becoming a cruel national joke to eventual exoneration, tragically long delayed, remains a potent symbol of the justice system's fallibility, the dangers of trial by media, and the sometimes incredibly long and painful road to establishing the truth.
A truly profound case exposing systemic vulnerabilities. Following that, a crisis that struck at the very top of the judicial system itself. The trials and parliamentary inquiries involving High Court Justice Lionel Murphy from 1985 to 1986.
Yes, an almost unprecedented event in Australian legal history, causing a major constitutional crisis. Lionel Murphy was a serving High Court justice, a prominent figure, a former Labor Attorney General known for his progressive and often controversial judgments and personality. Rumors and allegations began to surface, originating partly from illegally tacked phone conversations, that he had attempted to pervert the course of justice by trying to improperly influence a court case involving a friend, a Sydney solicitor named Morgan Ryan. This was famously captured in the alleged phrase, "What about my little Nate?" These allegations led to multiple Senate committee inquiries and eventually to criminal charges being laid against the sitting High Court judge.
So the central legal question was, on the face of it, did his interactions actually constitute the crime of attempting to pervert the course of justice? But fundamentally, the case tested whether anyone, even a High Court justice, could or should be held accountable before the ordinary criminal law for alleged misconduct. It tested the separation of powers in a profound way. How do you fairly investigate and potentially try a member of the nation's highest court? And what is the impact of such proceedings on the public's confidence in the judiciary's integrity?
Justice Murphy faced two highly publicized and politically charged jury trials in the NSW Supreme Court. The first trial, focusing on one specific allegation, resulted in an acquittal. However, the second trial, concerning a related but distinct allegation of attempting to influence a magistrate, resulted in a conviction. This sent absolute shockwaves across the country, a High Court judge convicted of a serious criminal offense. However, Justice Murphy appealed, and the NSW Court of Criminal Appeal later quashed that conviction in 1987, primarily due to procedural errors in the trial judge's directions to the jury and doubts about the sufficiency of the evidence.
So when he died, he was formally innocent in the eyes of the law.
Yes, that's correct. A planned retrial on the charge for which the conviction was quashed was aborted when Justice Murphy was diagnosed with terminal cancer. A parallel parliamentary commission of inquiry, set up to determine if his conduct amounted to proved misbehavior, warranting removal from the bench, was also aborted out of compassion given his illness. He passed away in October 1986, formally innocent as his conviction had been overturned and no other finding made against him. The Murphy affair was undoubtedly the greatest crisis to hit the High Court's integrity.
The key insight, perhaps, is how it demonstrated, albeit incredibly messily and controversially, that even members of the nation's highest court are not immune from investigation and suspicion, and the system can attempt, however imperfectly, to hold itself accountable. It certainly forced major reforms in how judicial misbehavior is investigated and handled in Australia. While his legacy as a brilliant and progressive judge remains strong for many, and some still argue the charges had a political motivation, the episode stands as a somber reminder of the immense ethical demands placed on the judiciary, the fragility of public trust, and the profound challenges of ensuring accountability at the highest levels when that trust is questioned.
From challenges at the very pinnacle of the judiciary to the often murky world of intelligence agencies, let's look at A.V. Hayden in 1984, the ASIS Sheraton Hotel case.
Yes, this was a really unusual case arising from a spectacularly failed clandestine training exercise by ASIS, the Australian Secret Intelligence Service, our overseas spy agency, back in 1983. A team of ASIS agents conducted a mock hostage rescue drill late at night in the Sheraton Hotel in Melbourne, but crucially, they did this without informing the Victoria Police or the hotel management, or indeed the unsuspecting hotel guests. They burst into corridors, brandishing deactivated firearms, smashed down a door, terrified guests who thought it was a real armed robbery or terrorist attack, and caused considerable damage. The whole thing quickly became a public fiasco and a major national embarrassment for the government when it hit the media.
And the Attorney General at the time sought court orders to protect the agents' identities and prevent the release of information about the operation, citing national security concerns. But immediately, questions arose about whether the agents had actually broken Victorian criminal law assault, property damage, firearms offenses.
Exactly. The central legal question became stark. Can government agents, operating clandestinely, claim immunity from domestic criminal or civil law for acts done in the course of their duties, even if those duties involve simulated violence or illegal entry? Could an executive instruction from a minister or the justification of national security training somehow make acts that would otherwise be unlawful, lawful? Did the concept of Crown immunity mean that intelligence agents essentially had a license to break the law during operations or training? The Victorian Supreme Court, in a decision whose principles were later effectively upheld by the High Court in the case known as A.V. Hayden, the anonymized name used to protect identities, gave a very firm and clear answer. Absolutely not. No person, not even intelligence agents acting under orders during a training exercise, is above the domestic law. The court held that executive instructions or agreements between ministers cannot override statutes or the common law. The fundamental principle is that the law applies equally to all. Necessity or national security concerns, while potentially relevant in policy or perhaps sentencing, do not unilaterally sanctify acts that are otherwise illegal under domestic criminal law. While the individual agents involved were not ultimately prosecuted, that was an executive decision based on public interest. The legal principle established was absolute and unequivocal.
A really fundamental affirmation of the rule of law, ensuring it applies even in the secret world of intelligence operations. What's the core insight here?
The key insight from A.V. Hayden is its powerful reinforcement of the principle that the rule of law penetrates even the most covert corners of government activity. It established clearly that intelligence agencies and their officers must operate within the bounds of domestic law. They do not have carte blanche to break laws simply because they are acting on government orders or for purported national security reasons, especially within Australia. The fiasco directly led to significant reforms, putting ASIS on a much clearer statutory footing with the ASIS Act 1986, establishing clearer constraints and parliamentary oversight mechanisms. The case remains a crucial precedent cited whenever executive action or national security claims push the boundaries of legality, reminding everyone that claims of national interest cannot, by themselves, justify acting outside the established laws of the land. The story itself is this bizarre mix of spy thriller absurdity, our spies causing chaos in a public hotel and bedrock legal principle, with the courts insisting that basic legal accountability still applies to everyone.
So many cases affirming the rule of law, even against powerful government interests or claims of necessity. Let's shift focus slightly now to how courts have developed principles of justice and fairness for individuals in other contexts, particularly in the realm of commercial dealings and contracts. Waltons Stores, Interstate, Ltd v. Maher in 1988.
Yes, this case is an absolute classic in Australian contract law, taught to every law student. It involved the Maher family, who owned commercial property in Nora, NSW. They were in negotiations to lease the property to Waltons Stores, a large national retailer. Based on strong assurances and encouragement from Waltons during these negotiations, essentially, Waltons indicated the deal was basically done and urged them to hurry. Mahers began demolishing their existing building and starting construction on a new one, specifically designed to Walton's specifications. Crucially, though, the formal lease documents hadn't actually been finalized and signed by Waltons. At the very last minute, Waltons, having had a change of strategy internally, decided not to proceed with the lease. And knowing full well that the Mahers had already started demolition in reliance on their earlier actions, Waltons deliberately instructed their lawyers to go slow and effectively went silent, letting the Mahers continue with the demolition.
So the Mahers were left high and dry with a half-demolished building, no tenant for their new custom-built store, and technically no binding contract because nothing had been formally signed and exchanged. What was the central legal question the High Court had to grapple with in this situation?
Could Waltons be held legally liable for the Mahers' significant loss, even though there was no formal concluded contract between them? The big question was whether the legal principle of promissory estoppel, which traditionally prevented someone from going back on a promise they made if another person had relied on it to their detriment, but was usually seen as a defense, a shield, could be used here, not just as a shield, but proactively as a sword. Could it be used as a basis for legal action to get compensation? Could the court use its powers of equity, the principles of fairness and good conscience, to prevent Waltons from acting unconscionably and effectively enforce the assumption the Mahers had relied upon, even without a formal contract? The High Court, in a landmark decision, ruled decisively in favor of the Mahers. This was a truly groundbreaking decision that fundamentally expanded the role of equitable estoppel in Australian law, establishing it clearly as a potential cause of action in its own right. They found Waltons had engaged in unconscionable conduct by encouraging the Mahers' assumption that the lease agreement would proceed as planned, and then standing by in silence while they suffered significant detriment by demolishing their building. The court used its equitable power to prevent that injustice, holding Waltons liable almost as if the contract had existed, awarding the Mahers substantial damages to compensate for their reliance losses, the cost of the wasted demolition and construction work.
This really sounds like a classic David and Goliath moment in the law, doesn't it? Protecting the little guy against a big corporation trying to use legal technicalities to get out of a moral commitment. What's the lasting insight?
The key insight from Walton's stores is precisely how it significantly expanded the power and scope of equitable estoppel, turning it into a potential sword as well as a shield in Australian law. It established that if there's a clear representation or promise, which is reasonably relied upon by someone to their significant detriment, and it would be unconscionable for the promiser to go back on their word, then equity can step in to enforce that promise or assumption, or at least provide compensation, even in the absence of a formally binding contract. It's become a powerful tool for ensuring fairness and preventing unconscionable conduct in commercial negotiations and dealings. It prevents larger, more sophisticated parties from using the strict technical requirements of contract law to take advantage of someone who has reasonably relied on their assurances. The image of that half-demolished building remains a potent symbol of why equity sometimes needs to intervene to prevent manifest injustice when the formal law seems insufficient. It's a really satisfying story demonstrating how the law can evolve to enforce a basic sense of commercial morality. That if you make a promise and encourage someone to act on it to their significant harm, you might well be held responsible for the consequences.
Enforcing fairness and good conscience even when the paperwork isn't technically complete. Okay, from the complexities of contract law to achieving some much-needed constitutional clarity. Our next case, Cole v. Whitfield from 1988, is perhaps less dramatic in its facts involving crayfish, but it proved to be absolutely revolutionary in its legal impact on understanding a key part of the Constitution.
It really is a fascinating example of that. The case revolved around Mr. Cole, who was prosecuted in Tasmania for possessing undersized crayfish that he had lawfully caught in South Australian waters and brought into Tasmania. His possession violated a Tasmanian law that set a minimum size for crayfish within Tasmania. He argued that this Tasmanian law impeded his freedom of interstate trade, thereby violating Section 92 of the Australian Constitution.
Ah, Section 92. That famous or perhaps infamous phrase, trade, commerce, and intercourse among the states shall be absolutely free. A clause which, as you mentioned earlier, had caused literally decades of confusion, conflicting interpretations, and endless litigation in the High Court since Federation in 1901. It was notoriously complex.
Absolute confusion is right. Section 92 jurisprudence was legendary for its complexity, its inconsistencies, its different competing theories over the years. The High Court, clearly recognizing this mess, seized this relatively simple case involving crayfish as a crucial opportunity to fundamentally rethink and finally settle the meaning of Section 92 once and for all. The central legal question was, how should that guarantee of absolutely free interstate trade actually be interpreted? Did it mean, as some old cases suggested, that any law that placed any burden on interstate trade was invalid? Or did it have a more specific meaning, focused perhaps on preventing protectionism? Was Tasmania's crayfish size limit a valid conservation measure, or was it actually a protectionist law unfairly disadvantaging out-of-state fishermen to benefit locals? In a remarkable display of unity and clarity, the entire High Court delivered a unanimous joint judgment that completely reformulated the test for Section 92. They effectively swept away nearly a century of confusing and contradictory precedents. They ruled definitively that Section 92 prohibits laws that impose a discriminatory burden of a protectionist kind on interstate trade and commerce. It does not mean that interstate trade is free from any regulation whatsoever. It only prohibits laws that discriminate against interstate trade compared to intrastate trade, typically for the purpose of protecting local industries from competition.
Okay, so how did that apply to Mr. Cole's undersized crayfish?
The court found that the Tasmanian law setting a minimum crayfish size applied equally to all crayfish found in Tasmanian waters, regardless of whether they were caught locally or brought in from interstate like Mr. Cole's. Its clear purpose was genuine conservation fish stocks, not protecting Tasmanian fishermen from South Australian competition. Therefore, because it wasn't discriminatory in a protectionist way, it did not breach Section 92. Mr. Cole's conviction stood. He lost his case.
But Australian constitutional law gained incredible clarity as a result. What's the key insight here?
The key insight from Cole v. Whitfield is how a relatively small case, seemingly about fish regulations, can trigger a major intellectual revolution in constitutional law, bringing much-needed order and clarity to a previously chaotic area. It decisively settled the meaning of Section 92 after nearly 90 years of confusion. It clarified that Section 92 is primarily about preventing economic protectionism and discrimination against interstate trade, not about creating an absolute, abstract personal right to trade free from any regulation. It established a clear, workable test: does the law impose a discriminatory burden of a protectionist kind? This largely settled Section 92 jurisprudence, dramatically reducing litigation in the area. There had been over 140 cases before this. It also exemplified a new approach to interpretation favored by the Mason Court, looking closely at the history and purpose of the clause from the 1890s constitutional conventions. It confirmed that states can regulate trade, even if it has some incidental effect on interstate commerce, provided the law has a legitimate, non-protectionist objective, like environment, health, or safety, and doesn't unfairly discriminate against interstate trade. It's a quirky but deeply satisfying story of how focusing on first principles and historical context brought decades of legal confusion to an end.
Order out of chaos, all thanks to some undersized crayfish. Finally, for this deep dive, let's return to that monumental struggle for Indigenous justice that began, in our discussion at least, with cases like Murrell and Mallorquin. The crucial next step towards overturning terra nullius came in 1988 with Mabo v. Queensland, 2-1.
Yes, this was the vital preliminary but absolutely crucial stage of the famous Mabo litigation that would eventually recognize native title. After Eddie Mabo and the other Miriam Islanders from Murray Island, Maher, in the Torres Strait, initiated their native title claim in the High Court, the Queensland government, led again by the formidable Premier Jobjoki Peterson, made a calculated and cynical attempt to extinguish any potential rights they might have had, aiming to kill the case before it could even be properly heard on its merits. They rushed through the Queensland Parliament, the Queensland Coast Islands Declaratory Act 1985. This act essentially declared, retroactively, that any traditional land rights the Miriam people might have held were completely extinguished back in 1879 when Queensland formally annexed the Torres Strait Islands. It was a direct legislative attempt to preemptively declare that native title, if it ever existed there, was definitely gone.
So they were literally trying to use state legislation to declare that native title simply never existed on those islands or was definitively extinguished decades in the past, purely to prevent the Mabo claim from succeeding in the High Court.
Precisely that. A direct legislative attempt to derail the entire lawsuit before the High Court could even consider the core question of whether native title existed at common law. The plaintiffs, led by Eddie McGreco, immediately challenged the validity of this Queensland Act in the High Court. They argued it was inconsistent with the Federal Racial Discrimination Act, RDA, of 1975, that same act we discussed in the Kawarta case.
Okay, so what was the central legal question the High Court had to answer in Mabo number 1?
was Queensland's 1985 Coast Islands Act, which specifically targeted the potential property rights of the Murrell people based on their race and historical connection to the land, invalid because it conflicted with the federal RDA under Section 109 of the Constitution, which says Commonwealth laws prevail over inconsistent state laws. Did attempting to extinguish potential indigenous land rights without compensation in a way that didn't apply to non-indigenous landowners violate the RDA's prohibition of racial discrimination concerning the enjoyment of property rights? The High Court found decisively in favor of Mabo and struck down the Queensland Act as invalid. A majority of the court ruled that the Queensland state law, by purporting to extinguish the islanders' traditional property rights simply because they were islanders, clearly discriminated against them on the basis of race and therefore ran afoul of the federal RDA's guarantees of equality before the law regarding property rights. Applying Section 109, the discriminatory state law was held to be invalid because it was inconsistent with the overriding Commonwealth law prohibiting racial discrimination in relation to land rights enjoyed after 1975. Queensland simply could not arbitrarily extinguish potential native title rights after the RDA came into effect in 1975 in a way that was racially discriminatory.
So this decision was absolutely crucial, wasn't it? Because it prevented Queensland from simply shutting down the Mabo claim legislatively. It ensured that the High Court would actually get to hear the substantive historical question of whether native title existed at common law. What's the key insight from Mabo, number one?
The key insight is how Mabo, number one, served as a vital legal shield, demonstrating the protective power of the Federal Racial Discrimination Act for the rights of Indigenous Australians against discriminatory state laws passed after 1975. It preserved the Murrell Islanders' fundamental ability to have their core native title claim heard on its merits by the High Court. It completely foiled Queensland's cynical legislative gambit designed to maintain the fiction of terra nullius by statute. It was a necessary, hard-fought victory that cleared the path legally and politically for the much larger, nation-changing legal revolution that was to come 4 years later. It showed the High Court was willing to use federal law to stand up to reactionary state legislation targeting Indigenous rights.
A crucial, necessary win, setting the stage for the historic decision itself. 4 years later, on that famous date, June 3, 1992, Mabo v. Queensland, number 2.
Yes, Mabo, number 2. This is arguably the single most important High Court decision of the 20th century in Australia. It was the culmination of Eddie Mabo's decade-long fight for recognition, tragically delivered just months after he had passed away from cancer. This was the case that finally, fundamentally, overturned the centuries-old legal doctrine of terra nullius and legally recognized the concept of Indigenous native title within Australian common law. Throughout the long trial phase, the Murrell Islanders presented extensive evidence of their deep, continuous, ongoing connection to Murray Island, their intricate customs, their laws of inheritance, their spiritual ties, and their systems of land stewardship stretching back over millennia. The Queensland government continued to argue the orthodox legal position that British colonization in 1788 had automatically extinguished any such pre-existing rights.
The central legal question facing the High Court couldn't have been more fundamental, could it? Does the common law of Australia recognize the pre-existing land rights of the Indigenous peoples who inhabited the continent and its islands before British settlement? Was terra nullius, the foundational idea that Australia was effectively no one's land, legally speaking, a just or factually correct basis for Australian property law? The court was essentially deciding between upholding a long-standing, convenient legal fiction or finally acknowledging historical reality and confronting the injustice it represented.
The High Court, by a decisive 6-1 majority, delivered its momentous judgment. They recognized that the Murrell people, and by logical extension, other Indigenous Australians who could demonstrate a similar continuing connection to their traditional lands, according to their traditional laws and customs, held traditional ownership rights that the Australian common law would now recognize and protect as native title. They explicitly rejected and swept aside the doctrine of terra nullius as unjust, discriminatory, and factually wrong, acknowledging the undeniable reality that Indigenous peoples had lived on, governed, and owned these lands for millennia under their own sophisticated legal and social systems. They ruled that where that traditional connection to land had been maintained, and where those native title rights had not been validly extinguished by clear and plain government action, like granting freehold title, then native title continued to exist as a burden on the Crown's underlying title.
This decision fundamentally reshaped Australia's legal landscape, its relationship with its Indigenous peoples, and arguably its national identity.
It absolutely did. The key insight from Mabo, number 2, is the High Court's radical, courageous act of admitting that a foundational principle of Australian property law for over 200 years, terra nullius, was based on historical fiction and a profound injustice. And critically, their willingness to adjust the common law itself to align it with historical truth and principles of justice. Justice Brennan's leading judgment contains that incredibly powerful passage stating that the common law could no longer, in good conscience, refuse to acknowledge history and the legacy of dispossession. It legally and symbolically recognized Aboriginal and Torres Strait Islander peoples as the original inhabitants and traditional owners of the land, overturning the myth that Australia was empty. It directly led to the Keating government passing the Native Title Act 1993, establishing complex processes for Indigenous groups to claim and prove native title. It has had profound, ongoing, and often contentious impacts on property law, resource development, land management, and the whole complex journey towards reconciliation in Australia. It was a moment where the legal system, pushed by the perseverance of Eddie Mabo and the Murrell people, demonstrated a capacity for profound change and moral reckoning, however long overdue.
A legal system capable of growth and sometimes correcting past wrongs. Okay, from the monumental recognition of collective land rights, let's shift back to the rights of individuals within the criminal justice system. Our next case is Dietrich v. the Queen, also from that pivotal year, 1992.
Yes, another landmark from '92. This case involved Olaf Dietrich. He was arrested after arriving in Melbourne from Thailand with a quantity of heroin concealed internally. He was charged with importing a trafficable quantity of heroin, a very serious indictable offense carrying a lengthy potential prison sentence. He couldn't afford a private lawyer, and he was refused legal aid by the Victorian Legal Aid Commission because he refused to plead guilty. He insisted on his right to plead not guilty and have a trial. As a result, he was forced to represent himself during a lengthy and complex trial in the County Court of Victoria.
Representing himself on such a serious charge, that sounds incredibly difficult, and he was convicted. He appealed his conviction, arguing that being forced to stand trial for such a serious crime without legal representation amounted to a miscarriage of justice. What was the central legal question the High Court had to decide?
Does an accused person facing a serious criminal charge in Australia have a right to legal representation? And more specifically, if they cannot afford a lawyer and they are unable to obtain legal aid through no fault of their own, like Dietrich, who was denied aid unless he pleaded guilty, should the trial be delayed or stayed unless and until the state provides them with counsel? Did the common law right to a fair trial, which everyone is entitled to, implicitly include the right to legal representation at public expense if necessary in serious criminal cases? The High Court, in a significant 5-2 majority decision, established a really important precedent. While they stopped short of declaring an absolute constitutional right to state-funded counsel in all circumstances, they ruled that, as a general rule, a trial for a serious indictable offense should be stayed, meaning delayed or stopped by the judge, if the accused person is unrepresented through no fault of their own. They reasoned that proceeding with a trial against an unrepresented accused in such serious circumstances would, in most cases, result in an unfair trial, and therefore constitute an abuse of the court's process. As a result, Dietrich's conviction was quashed, and a retrial was ordered. Although in practice, he had served a significant portion of his sentence by then and was effectively released.
So, while not an absolute right to a lawyer, the practical effect is pretty similar, isn't it? If you're facing a serious crime and genuinely can't get a lawyer, the state basically needs to ensure you get one, or the trial probably can't proceed fairly.
That's essentially the practical effect, yes. The key insight from Dietrich is how it significantly strengthened the common law right to a fair trial in Australia by establishing a practical entitlement to legal representation in serious criminal matters, even without creating an explicit constitutional right to publicly funded counsel. It put significant pressure on governments across Australia to adequately fund legal aid services for serious criminal cases. It raised the standard significantly for what constitutes a fair trial in our adversarial system, recognizing that complex trials require skilled legal advocacy on both sides for justice to be properly done. It's a powerful example of how the courts can, through developing common law principles like the right to a fair trial, create significant practical safeguards for individual rights and ensure a more level playing field in the criminal justice system.
A vital safeguard, ensuring a fair process in the most serious cases. Okay, next, a case dealing with profoundly difficult ethical and legal questions concerning the rights of children with severe disabilities. Secretary, Department of Health and Community Services, NT, v. JWB, and SMB in 1992, widely known as Marion's case.
Yes, another incredibly difficult case from 1992. This deeply sensitive case involved Marion, who was a 14-year-old girl living in the Northern Territory with severe intellectual disabilities and other conditions. Her parents, who were her primary carers, sought permission from the Family Court of Australia to have her sterilized specifically to have a hysterectomy and an ovaryectomy, primarily to prevent menstruation, which caused her distress, and also to prevent any possibility of pregnancy in the future, as they believed she would never be capable of understanding or consenting to sexual activity or raising a child, and they felt it was in her overall best interest.
This case raised huge fundamental ethical dilemmas, didn't it? Who gets to decide about such a life-altering, irreversible medical procedure for someone who cannot possibly consent themselves? What are the fundamental rights, including the right to bodily integrity and reproductive capacity, of intellectually disabled minors?
Exactly. The central legal question the High Court had to determine was, does the family court, or indeed any court, have the legal authority to authorize the sterilization of a child who cannot consent, and if so, under what specific circumstances? Could parents, acting under their general parental authority, consent on the child's behalf for such a procedure, or did this type of irreversible non-therapeutic medical intervention require specific court oversight and authorization? It really delved into the scope of parental authority versus the court's protective parents' patria jurisdiction, its inherent role as the ultimate guardian of children and others unable to protect their own interests. The High Court, in a majority decision, ruled that court authorization is absolutely required for the non-therapeutic sterilization of a minor who cannot consent for themselves. They held that sterilization is such an invasive, irreversible procedure with such grave consequences for a person's fundamental rights and future life, and carries such a significant potential for abuse, recalling historical eugenics practices, that the decision falls outside the bounds of ordinary parental power to consent to medical treatment. Only a court, after applying a very stringent test focused solely and paramountly on the child's best interests, not the interests of the parents or carers, could potentially authorize such a procedure. While they didn't ban it outright in all conceivable circumstances, they set an incredibly high legal bar and insisted on rigorous judicial scrutiny. The case was sent back to the family court for determination under this strict test, and subsequently, court authorizations for sterilization of minors became exceedingly rare and subject to very strict protocols.
So parents simply cannot unilaterally make that decision for a child with intellectual disabilities regarding sterilization. What's the lasting insight from this incredibly complex case?
The key insight from Marion's case is how it established a fundamental legal safeguard for the bodily integrity and reproductive rights of children and young people with intellectual disabilities who lack the capacity to consent for themselves. It confirmed definitively that such a profound and irreversible procedure as sterilization cannot be decided by parents or guardians alone, however well-intentioned they may be, but requires stringent, independent judicial oversight to protect the fundamental human rights of the vulnerable individual involved. It powerfully underscored the principle that the courts have a vital role in protecting the rights of the most vulnerable members of society, even when faced with incredibly complex and emotionally charged decisions. It emphasized that a child's fundamental rights, including the right to bodily integrity and future reproductive capacity, must be carefully and rigorously protected by the legal system. It remains a landmark decision in Australian family law and disability rights law.
Protecting the vulnerable through stringent legal process and oversight. Another really important case from 1992 that significantly reshaped a fundamental relationship, this time the one between doctors and their patients. Rogers v. Whitaker.
Yes, this case involved Mrs. Prue Whitaker. She'd been blind in her right eye since childhood. She consulted an ophthalmic surgeon, Dr. Christopher Rogers, seeking surgery on that blind eye, primarily to improve its appearance, but also perhaps hoping for some restoration of sight, though that wasn't the main goal. Dr. Rogers recommended a particular surgical procedure. Mrs. Whitaker specifically asked about risks, particularly any risk to her good left eye. Dr. Rogers assured her the risks were low. Tragically, during or shortly after the surgery on her blind right eye, she developed a very rare condition called sympathetic ophthalmia, an autoimmune response which caused inflammation and eventually blindness in her good left eye as well, leaving her completely blind. Mrs. Whitaker sued Dr. Rogers, not alleging that he performed the surgery negligently, but crucially, arguing that he was negligent in failing to warn her of that specific, albeit remote, risk of sympathetic ophthalmia occurring. The risk was estimated at about 1 in 14,000.
Okay, so the central legal question was all about the duty to warn. What exactly is the extent of a doctor's legal duty to warn patients about the inherent risks associated with a proposed medical procedure? Was Dr. Rogers negligent in not specifically informing Mrs. Whitaker of this remote but catastrophic risk? And importantly, should the standard for what risks need to be disclosed be determined by what a reasonable body of medical practitioners would typically do in the circumstances? That was the traditional Bolam test used in England and previously influential in Australia. Or should the court set the standard based more on the patient's right to receive the information they need to make an informed decision about their own body?
The High Court unanimously found in favor of Mrs. Whitaker, upholding the trial judge's finding of negligence. In doing so, they decisively moved Australian law away from the doctor-centric Bolam test for the duty to warn. They ruled that a doctor has a duty to warn a patient of material risk associated with proposed treatment. And they defined a material risk as a risk which, in the circumstances of the particular case, a reasonable person in the patient's position, if warned of the risk, would be likely to attach significance to it. Or, alternatively, a risk that the doctor knows or should reasonably know that this particular patient, if warned, would be likely to attach significance to. They explicitly rejected the idea that the standard could be set solely by prevailing medical practice. The ultimate standard is set by the court. In Mrs. Whitaker's case, given the catastrophic consequence of the risk, total blindness, and the fact that she had specifically expressed concern about her good eye, the risk of sympathetic ophthalmia, however statistically rare, was clearly material and should have been disclosed to her before she consented to the surgery on her blind eye.
This sounds like it's significantly shifted the balance of power in the doctor-patient relationship, really empowering the patient, didn't it? What's the key insight?
The key insight from Rogers v. Whitaker is exactly that. It fundamentally transformed the legal standard for informed consent in Australian medical practice. It shifted the focus of the law decisively away from medical paternalism, doctor knows best, towards patient autonomy and the right to self-determination. It established clearly that doctors have a legal duty to inform patients of all material risks a reasonable patient would want to know about, even if those risks are statistically rare, so that patients can make their own truly informed choices about whether or not to undergo treatment. This decision is taught to every medical student in Australia and has dramatically improved doctor-patient communication regarding risks and benefits. It ensures patients have the information they need to make decisions that align with their own values and assessment of risk. It's a poignant story of a terrible personal tragedy leading directly to a landmark legal principle that has significantly benefited countless patients by empowering them in their healthcare decisions.
Patient empowerment in the medical sphere, and perhaps empowerment in the political sphere, too. Also in that incredibly busy legal year of 1992, with Australian Capital Television, ACTV, a LTDV Commonwealth, often called the ACTV case.
Yes, another huge one from 1992. The Commonwealth Parliament, under the Hawke Labour government, passed legislation that imposed a near-total ban on paid political advertising on radio and television during federal election campaign periods. Some limited free airtime was allocated to qualifying political parties instead. The stated aim of the legislation was campaign finance reform to try and level the playing field between incumbents and challengers, reduce the potentially corrupting influence of money in politics, and perhaps improve the quality of political discourse by reducing reliance on short, expensive attack ads. However, various media companies, political parties, especially minor ones, and others immediately challenged the constitutional validity of this law. They argued it infringed a freedom that wasn't explicitly written down in the Australian Constitution, but which they argued was necessarily implied by the system of government it established.
An implied freedom. Now, as we've discussed before, Australia doesn't have a formal Bill of Rights or an explicit free speech clause like the U.S. First Amendment written into its constitution. So where could such a freedom possibly be found? How could they argue it existed?
That was precisely the central groundbreaking legal question. Did the structure and text of the Australian Constitution, specifically those sections establishing the Parliament as being directly chosen by the people, Sections 7 and 24 dealing with the Senate and House of Representatives, necessarily imply a fundamental freedom of communication on political and governmental matters? The argument put forward by the challengers was that for representative and responsible government to function effectively, voters must be able to receive and impart information and opinions about political matters freely, especially during an election campaign. Could Parliament legitimately restrict this core political speech through a near-total ban on paid advertising? Or was open political debate constitutionally protected as essential to the democratic process itself? The High Court's decision here was truly revolutionary for Australian constitutional law. In a 5-2 majority decision, delivered alongside a related case, Nationwide News v. Wills, The High Court struck down the advertising ban, finding it unconstitutional. In doing so, they effectively discovered and established a new, previously unrecognized constitutional freedom, an implied freedom of communication on political and governmental matters. While they emphasized it wasn't an absolute personal right to free speech in the American sense, they ruled that Sections 7 and 24, which underpin Australia's system of representative democracy, necessarily require a degree of freedom for citizens, candidates, and the media to communicate politically so that voters can make informed choices and hold their representatives accountable. The court found that the law's blanket ban on paid political advertising during election periods was too broad, went far beyond what was necessary to achieve its stated aims, and was therefore an impermissible burden on this implied freedom. It was declared invalid.
This is widely considered Australia's closest equivalent to a constitutional guarantee of free speech, specifically focused on political speech. What's the core insight from this landmark decision?
The key insight from ACTV is how the High Court, at a particular point in its history under Chief Justice Mason, was willing to infer a fundamental freedom deemed essential to the practical functioning of Australia's system of representative democracy, from the very structure and text of the Constitution itself. Even though that freedom wasn't explicitly spelled out, it breathed active constitutional protection into the realm of political speech. Since ACTV, laws that restrict political communication, whether they relate to protesting, electoral spending, defamation law concerning politicians, or national security limitations on speech, are now tested against this implied freedom to see if they are a legitimate and proportionate burden. It signaled the High Court's willingness to interpret the Constitution purposively, looking to underlying democratic principles. It significantly impacted how election campaigns are conducted. Future attempts at regulating political advertising had to be much more carefully tailored. It remains a cornerstone, albeit a sometimes debated and refined one, like in the later Lange case, of modern Australian constitutional law. It's a powerful story of media outlets and others challenging government attempts to control the flow of political messaging, resulting in a landmark judicial affirmation that open, robust political debate is constitutionally essential for a functioning democracy.
A vital new freedom discovered, or perhaps uncovered, within the existing constitutional text. Okay, finally, our last case for this deep dive, taking us to 1996. Cabell v. Director of Public Prosecutions, NSW.
Yes, the Cable case. This case concerned a man named Gregory Cable. He had been convicted of the manslaughter of his wife and had served his sentence, nearing his release date. However, the NSW state government considered him to be an ongoing danger to the community, particularly to members of his deceased wife's family. In a highly unusual and controversial move, the NSW Parliament passed a special piece of legislation called the Community Protection Act 1994. Crucially, this act was drafted specifically and only to apply to Gregory Cable by name. It was what lawyers call an ad hominem law. It empowered the NSW Supreme Court to order Cable's ongoing preventive detention in prison after his sentence had officially expired if the court was satisfied on the balance of probabilities that he was likely to pose a serious danger to the community if released. This detention could be ordered for periods of up to 6 months at a time, potentially indefinitely, and lack many of the usual procedural safeguards associated with criminal trials and punishment.
So the state parliament passed a law specifically targeting one single individual by name, allowing a court to effectively lock him up indefinitely after he'd served his time, based not on a crime he'd committed, but on a prediction of future dangerousness and bypassing normal criminal procedures. That sounds like something out of a dystopian novel and immediately raises incredibly serious rule of law concerns, doesn't it?
It absolutely does. It was highly controversial from the moment it was proposed. Cable, naturally, challenged the constitutional validity of this unique act. The central legal question before the High Court was profound. Could a state legislature validly pass a law that effectively conscripted its own state Supreme Court, a court vested with judicial power to exercise a function that appeared fundamentally incompatible with the court's essential character as an independent and impartial judicial tribunal? Specifically, could the state force its Supreme Court to order the detention of a specific individual based on a prediction of future dangerousness in a process that looked more like an administrative decision than a traditional judicial finding of guilt for past conduct? And crucially, given that state courts are part of the integrated Australian judicial system established under Chapter 3 of the Federal Constitution and can exercise federal jurisdiction, did the federal structure itself impose limits on state parliaments, undermining the institutional integrity and independence of their own courts? The High Court, in a significant and groundbreaking 4-2 decision, struck down the NSW Community Protection Act as unconstitutional. In doing so, they developed what is now known as the cable principle, or cable doctrine. This principle holds that because state courts are part of an integrated Australian judicial system established by Chapter 3 of the Constitution and are repositories of federal judicial power, state legislatures cannot confer powers or functions on them that are incompatible with their institutional integrity and their character as independent and impartial courts. The High Court found that the NSW Act, by targeting a specific individual, Cable, and requiring the NSW Supreme Court to participate in detaining him based on a prediction of future dangerousness rather than a finding of criminal guilt in a process that lacked normal judicial safeguards, was repugnant to the traditional judicial process. It compromised the institutional integrity of the NSW Supreme Court, making it appear to be acting as an instrument of executive policy rather than an independent arbiter of law. Therefore, the act was held to be constitutionally invalid.
This is a really groundbreaking check on state legislative power over their own courts, isn't it? And it's derived not from a state constitution or Bill of Rights, but from the structure of the federal constitution. What's the core insight here?
The key insight from Cable is precisely that. How the High Court used the structure of the federal constitution, particularly the integrated court system envisaged by Chapter 3, to impose a significant limitation on state legislative power over state courts. It established the crucial principle that state parliaments cannot pass laws that require their courts to act in ways that fundamentally compromise their institutional integrity as independent courts, particularly by forcing them to become mere instruments of government policy, to dispense with fundamental judicial processes, or to act in ways that depart radically from traditional judicial methods, like imprisoning people predictably rather than punishing past acts. The Cable Doctrine has since been invoked, sometimes successfully, sometimes not, to challenge other state laws that are seen as undermining judicial independence or fairness, though the bar is set very high. It stands as a powerful affirmation of the rule of law. Governments cannot simply pass special laws targeting unpopular individuals and use the courts as a veneer for indefinite detention without adhering to fundamental judicial processes. It was a significant rebuke to what was seen as a populist move by the NSW government, underscoring that even the most unpopular or potentially dangerous individuals are protected by the constitutional requirements of judicial independence and procedural fairness. It's a stark reminder of why maintaining the integrity and independence of the courts is so vital to protecting liberty against arbitrary government action.
We've certainly journeyed through just a fraction, haven't we, of the cases that really form the backbone of Australian law. From those earliest colonial courts struggling with the fundamental questions of Indigenous sovereignty and frontier violence.
Right through to the High Court, grappling with the delicate balance of federal power, the very definition of individual rights, economic, political, personal, and, as we just saw, the fundamental integrity of the justice system itself.
And as we've seen, these weren't just dry legal rulings you'd find in dusty old books. They were often incredibly dramatic turning points, weren't they? Forged in real conflicts, shaped by individual courage and sheer perseverance sometimes, and reflecting these profound societal shifts.
Absolutely. They challenged long-held assumptions, they corrected injustices, though often, as we saw, very slowly and imperfectly, and they really defined the character of the nation at crucial moments in its history.
And they vividly show that the law isn't static, is it? It's a living, evolving thing, constantly being tested and refined in the crucible of real disputes involving real people with real lives at stake. And these historical battles, well, they continue to influence your life today, underpinning rights and structures you might just take for granted, everything from the minimum wage you earn, the environmental protections we have, to your right to a fair trial if accused of a crime, and the limits on government power.
Yeah, they're a testament to that dynamic interplay between law, society, and power, and the enduring, often difficult, pursuit of justice within that complex framework.
So, reflecting on this ongoing story of legal struggle and evolution, from the initial stark denial of ancient indigenous laws and the early brutal struggles for basic rights, right through to the eventual recognition of native title and the establishment of modern freedoms and these vital safeguards against arbitrary power, what does it all reveal about a society's capacity, or perhaps its struggle, to learn from its past? What does it tell us about the challenge and the enduring necessity of striving to truly uphold justice for all its people, especially, when faced with deeply ingrained beliefs, moments of intense fear, or that powerful political urge to just bypass due process for expediency? It's a story, isn't it, that continues to unfold, and one that's constantly being shaped by our ongoing engagement with these fundamental legal principles.